Welcome to the Deep Dive. Today we're doing a deep analysis of the U.S. data privacy landscape, which is, well, it's expanding at a dizzying pace.
It really is.
Our focus is on what we're calling the class of 2026. That's a new set of consumer privacy laws set to go live in Indiana, Kentucky, and Rhode Island.
And this isn't just some, academic exercise. We are looking at a compliance tidal wave. It's coming straight for any business that relies on monetizing consumer data.
A tidal wave?
For sure. The regulatory risk is accelerating, and it's forcing companies to completely rethink revenue streams and deal with, frankly, massive operational complexity across state lines.
Okay, that sets the stakes perfectly.
Yeah.
So let's jump right into the core of it. This January 1st, 2026 privacy blitz.
Right.
We've got three comprehensive laws, the Indiana CDPA, the Kentucky CDPA, and Rhode Island's DTPA, all scheduled to go live at almost the exact same time.
Pretty much, yeah.
So what's the immediate measurable impact of this tri-state expansion?
Well, the first thing is just scale and logistics. When these laws kick in on January 1st, 2026, the total number of states with comprehensive privacy laws jumps to 19. 19. So if you're a company operating nationwide, you suddenly have nearly 20 different masters to serve. Each one demands slightly different data protocols. It requires immediate and deeply technical compliance changes.
And if that compliance isn't perfect, the costs are steep.
Yeah.
But I'm guessing they're not uniform?
Not at all. And that lack of uniformity is the real risk. Indiana and Kentucky, they carry penalties up to $7,500 per violation.
Okay, which is substantial.
It's substantial, but maybe manageable if it's a small mistake. But Rhode Island, they raise that ceiling to $10,000 per violation. And critically, they tack on extra penalties for sensitive data disclosures.
How much extra?
Between $100 and $500 per disclosure. So one mistake in a user database could just hammer the bottom line.
That financial distinction, though, it really forces us to talk about the main vulnerability here, the cure period, or I should say the total lack of one in Rhode Island.
Exactly. This is the difference between a warning and a hammer blow.
So how does it work in the other states?
Indiana and Kentucky both offer a permanent 30-day cure period. The state attorney general tells you there's a problem, and you get 30 days to fix it before any penalties hit. It's a grace period, for honest mistakes.
What non-Rhode Island's?
Rhode Island, zero grace, no cure period. If you're found in violation, the fines can be levied immediately.
Wow.
That zero tolerance approach, it just fundamentally changes the risk calculation. A violation in Kentucky is a compliance headache. A violation in Rhode Island is an immediate financial disaster waiting to happen.
It sounds like Rhode Island is just saying, get your data house in order before you even start.
That's pretty much it.
But this didn't happen overnight. Let's look at the history, because there's clearly a massive legislative momentum building here ever since California led the way back in 2018.
Oh, for sure. California broke the ice, but the real wave came after. We saw this steady, compounding buildup through 2023, 2024. And by mid-2025, we had about 21 states with these big omnibus laws enacted.
And most of those are in effect now.
17 are currently in effect. But here's a little footnote. 2025 was actually the first year since 2018 that a new law wasn't enacted. It was like a brief pause.
A deep breath before the next surge.
Precisely. We know 2026 is going to be pivotal. We already have 16 state legislatures that have introduced new bills, including big markets like Massachusetts, Georgia, and Pennsylvania. The pipeline is full.
So if this expansion is just inevitable, are these laws at least uniform in how they're structured? Or is it really this fragmented patchwork problem that everyone fears?
They do share a common core, a philosophical one at least. All the recent state laws are rights-based. They grant consumers the right to access, correct, delete, and port their data.
In opt-out rights.
And mandatory opt-out rights for data sales, targeted advertising, and certain profiling. And, enforcement is always with the state attorney general. That's the good news.
Okay. And the bad news is in the operational details.
The operational details are where the compliance budget just bleeds out. Just take the applicability thresholds. In Indiana and Kentucky, the law kicks in if you process data for, say, 100,000 consumers,
right,
or 25,000 if you get over half your revenue from selling data. Those are pretty high bars for a smaller regional business.
But Rhode Island's bar is lower, so it catches smaller players.
Much lower. Rhode Island's threshold is just 35,000 consumers, or 10,000 if you get just 20% of your revenue from data sales. So a small software vendor in Providence could suddenly be on the hook.
While a much bigger company in Indiana might be exempt.
Exactly. It feels like they're using totally different yardsticks.
And the divergence goes beyond just the number of consumers, right? What about definitions?
Definitions are a complete nightmare for the tech teams. California regulates cross-context behavioral advertising, which is a very specific technical term. Other states just say targeted advertising.
And those might not be the same thing.
They may or may not cover the same exact practices. So compliance teams have to build slightly different technical fences for every single one of those 19 states.
And then you get to the, frankly, absurdity of some requirements around sensitive data. You mentioned geolocation. It sounds like states are forcing companies to measure compliance down to the foot.
They are. The definition of precise geolocation is what triggers the sensitive data protection, which, again, requires that explicit opt-in consent. But different states have different ideas of precise.
How different?
Kentucky says it's within 1,750 feet. Colorado uses 1,850 feet. Maryland has its own number.
Wait. You're telling me a national company has to build different compliance models based on a distinction of 100 feet? That's just arbitrary.
It's the perfect embodiment of the patchwork penalty. It forces companies to spend huge sums of money not on protecting privacy, but on adapting to these tiny non-substantive differences. And remember, all three of our new states, Indiana, Kentucky, and Rhode Island, require that explicit opt-in consent for any data deemed sensitive.
So let's pivot to the investor context. When we look at this operational friction, who's getting caught in the net, really?
Well, the laws generally exempt the usual suspects, financial institutions under GLBA, healthcare under HIPAA, B2B data, but they apply broadly to pretty much the entire consumer ecosystem.
Like retailers.
Retailers, manufacturers, any software vendor with consumer interaction. These non-exempt segments are facing dramatically rising compliance costs that cut right into their margins.
And the spotlight seems to be shining brightest on how companies monetize sensitive data. That's a core vulnerability for ad tech.
Absolutely. And we're seeing protection expand beyond just traditional health data. Take Virginia's SB 754. It specifically protects reproductive or sexual health information, even if it's just inferred from other data. So if you're targeting ads to new parents or tracking location data near certain types of clinics, that is now a huge regulatory focus. And Maryland just took the most aggressive step and banned the sale of sensitive data entirely.
That structural risk brings us to maybe the biggest threat to a lot of business models, the crackdown on data brokers, which is really being driven by California.
This is the critical change. The definition of who is a data broker is expanding far beyond what you traditionally think.
How is it expand? I mean, if I'm a first-party retailer, I'm protected by my direct relationship with the customer, right?
That protection is eroding fast. California's CPPA is using its regulatory power to redefine that direct relationship. The new rules suggest it has to be an intentional, expected interaction between the consumer and the business.
Give me an example of how that sweeps in a retailer.
Okay. Imagine a consumer goes to a retailer's website to buy shoes. That's an intentional interaction. But if that same retailer also collects browsing data when the consumer is on a different website and then sells that secondary data,
they could suddenly be classified as a data broker.
Exactly. This dramatically expands the compliance net. Texas also recently hardened its definition. It's sweeping in a lot of companies that historically relied on monetizing these third-party data streams.
And we have recent enforcement actions that act as a kind of forecast for where compliance budgets need to go.
Nice.
What are the lessons from California's actions?
California is sending two very clear signals. Enforce purpose limitation and eliminate dark patterns. Take the $1.55 million settlement against Healthline.
Right.
They got fined because they were sharing article titles that revealed medical conditions. That data sharing went way beyond the original purpose for which the data was collected.
So it's about vendor oversight and purpose limitation.
Absolutely. And the dark patterns, that's all about the opt-out experience. The fines against Honda and the apparel company Todd Snyder, they emphasize that opt-out tools have to actually work and not be deceptive.
Explain what you mean by dark patterns.
Think about it this way. The accept all cookies button is bright green, one click. But reject all is hidden behind 3 pages of gray, confusing menus. That's the asymmetry of choice that the Connecticut AG is targeting.
So they want symmetry.
They want functional parity.
Yeah.
Make it easy to accept, make it just as easy to reject. It shows this isn't just a legal exercise, it's a technical and design requirement now.
And we're even seeing these rules start to bleed into new technologies, like AI.
This is the next frontier of friction. Connecticut now requires notice if personal data is used to train large language models. That's a massive shift.
Yeesh.
And New Jersey is proposing requiring consent for using personal data in AI systems. The definition of AI is still murky, but the intent is crystal clear. Privacy consent is becoming a foundational layer for AI development.
Okay, so that volatility and rising risk, it all translates into investment signals. Let's move into our This Is Not Financial Advice segment. What's an outrageous but plausible trade idea based on this landscape?
Given this convergence of state laws, the threat of Rhode Island's zero-cure period, and the expanding definition of data broker, the most structurally sound idea is shorting entities that depend on opaque third-party data.
So smaller data aggregators, ad tech firms.
Exactly. The combination of mandatory opt-in for sensitive data, the geolocation rules, and the rise in wiretapping lawsuits creates this immediate, almost existential risk for business models that are now regulated in 19 different ways.
Okay, so short the players whose model treats user data as a free asset. What's the inverse trade? The long position.
Going long on compliance infrastructure and governance services, this regulatory demand is irreversible. Companies need data processing agreements. They need to conduct data protection impact assessments. They need expert legal counsel for 19 different state laws.
So you're betting on the compliance budget.
That budget is only going in one direction, significantly. So you look at publicly traded compliance software vendors, consent management platforms, or even law firms with dedicated privacy as a service solutions.
That brings us to our final thought then. This January 1st, 2026 deadline for Indiana, Kentucky, and Rhode Island, it really just solidifies this trend. Regulatory expansion is aggressively targeting data monetization and, crucially, blurring the definition of who is a data broker.
Right. And this creates a new kind of inventory risk. It's almost like how environmental liability started getting priced decades ago. If state regulations keep blurring the line between a first-party business and a regulated data broker, the question for Wall Street becomes,
how do you price that risk?
Exactly. How will analysts formally price the long-term data inventory risk and the regulatory exposure for major consumer-facing platforms? Is a batch of precise geolocation data now a toxic asset that could trigger a $10,000 fine per user in Rhode Island? That risk premium is just increasing with every new state law.
That is the complex reality facing the C-suite today. We encourage you to share your own perspectives and compliance challenges with us as this critical deadline approaches.
And remember, this is not financial advice.
Thank you for joining The Deep Dive.